All right, everyone, we are live. Thank you so much for joining us this evening. Zac Morgan, how are you, sir?
I'm good, Aaron. I appreciate you putting this together last minute. Your viewers probably don't understand that this was, I think, at my request rather than yours. Normally, you reach out and say, "Hey, what do you have to say about this?" But I got with you and said, "Hey, can we do this?"
Yeah, well, I was excited to see what you wanted to talk about because it's something I haven't heard discussed. And let's just get right into it. So, how does the district attorney's decision to either retry this case, the Danny Masterson criminal case, or to dismiss the charges affect Danny Masterson's testimony in the civil trial that is currently on hold pending the result of the criminal trial?
Sure. So ultimately, the decision is big, and it's big in one of two ways. If the district attorney elects not to retry Danny Masterson, the charges will be dismissed. And that's the term everybody throws around, but there's actually two types of dismissal. They are vastly different and have enormous legal consequences. There's something called a dismissal with prejudice, and that's short for dismissal with prejudice to refiling the same claim. So if the DA dismisses this case with prejudice, the DA can never charge Danny Masterson under the one strike statute with these three Jane Does as victims again, ever. If the DA dismisses it without prejudice to refiling, it means that the DA can, at some point, if they choose to, come back and try and recharge Danny. And the reason that is significant, if they dismiss it with prejudice, saying we give up, we are never going to prosecute you again for these claims as it pertains to the one strike law in Jane Does 1, 2, and 3, Danny Masterson can no longer assert the Fifth Amendment privilege as it pertains to those Jane Does. Because even if he says, I did it, he can't be prosecuted. It's very similar to immunity that we talked about in Lisa Marie Presley. If the DA says, I'm going to dismiss it without prejudice so I can think about refiling charges later, Danny Masterson can, and likely on the advice of counsel would. If I'm his attorney, my advice is you don't answer questions, because the DA could use that testimony to come back and prosecute him later. So there's a huge difference in with prejudice and without prejudice. And most people, unless you're in the legal world, don't even know that those two different types of dismissals exist, but they are vastly different in effect.
Very interesting. So if the DA dismisses with prejudice, and just to make sure I'm following that means he can never be retried for the charges for these women again ever.
Correct.
And if Danny were to try and plead the fifth in the civil testimony, what would the judge in that case do?
If he was asserting the fifth for anything that happened with Jane Doe's 1, 2, or 3, he would be forced to testify. He would be forced to answer the question. If it pertained to something else, for example, Jane Doe 4, or any other of what I can only assume are additional Jane Does that either haven't come forward or their coming forward has not been yet made public. In that case, if it's Jane Doe 4 or anybody other than Jane Does 1, 2, and 3, the Fifth Amendment can still be asserted. But as it pertains to Jane Does 1, 2, and 3, he can no longer assert the Fifth Amendment privilege if it's dismissed with prejudice.
Okay. Now, I thought that when you invoked the fifth or pled the fifth or whatever the best language is, what language would you use?
Either way, so the when I say I plead the fifth, I take the fifth, what you're doing is you're actually invoking the fifth. So the action would be invoking it. The rest of those are just words that you would use to tell the judge.
So I thought that when you invoked the fifth, you didn't have to say why you were invoking it because that would be like sort of giving it away. So couldn't he just sit there and plead the fifth and refuse to say why?
He could, but it's a question by question assertion. Mr. Masterson, did you have were you involved in certain types of conduct with Jane Doe 1 while she was intoxicated or unconscious? Yes or no? He can't assert the fifth to that if it's dismissed with prejudice because he's protected.
Okay.
But if it says, have you ever in your life, not limited to Jane Doe 1, 2, or 3, but ever in your whole life, that question's broad enough that he could assert.
Okay. And I'm just really curious how this would play out. If he insisted on continuing to take the fifth, would he basically be in contempt of court and possibly go to jail for that? Like what's
Yeah, so he would, but here's the reality of trial, right? If he asserts it at trial, the judge will put him in jail, and the purpose is when you go to jail for a contempt charge, it is not to punish you. It's actually to compel you to comply with the court order. And if you just go to jail and say, you know what, like this is the Muhammad Ali approach, right? I'm going to go to jail and not answer the question. Well, you have acknowledged that the contempt can never be cured by you answering the question. So in that case, the judge would likely issue an instruction to the jury that says, Mr. Masterson is not allowed to assert the Fifth Amendment. He has been ordered to answer the question. He has chosen not to. Therefore, I am instructing you that as the jury, as a matter of law, you are to draw what's called the adverse inference, that any testimony he would have given in response to this question would have been damaging and would have been detrimental to him. So the judge will tell the jury, you are to treat this as, yes, I did these things.
Very interesting. So what criteria is the district attorney working with? What information is he basing his decision on, whether to dismiss with prejudice or without?
Oh, probably. So if let's use the Jane Doe 1 vote. Let's set aside Jane Doe 2 and 3, but just use the Jane Doe 1 vote. Right now, 2 and 11. If that's my only charge, I'm not going to retry. 2 and 10, I'm not going to retry it. I've got too many jurors I got to turn. Now I've got other. That's why we ignore 2 and 3 for now. The question is, how do I ignore it, or how do I dismiss it? And if I know that I'm never going to get a jury to convict, just not good facts, not a good witness, whatever, maybe adverse ruling, whatever. If I know, if I'm convinced I'm never going to get a conviction, dismiss it with prejudice, because the state knows that the civil trial is on hold. Right. And it's one of those things that if I know I'm not going to get a conviction, I'm going to dismiss it with prejudice, and maybe I can find other things to charge him with later. But as it pertains to this, I close the file and I move on.
Very interesting. So it probably, since the women involved in the criminal case, I found out yesterday, I didn't actually understand this before, all 3 of the Jane Does are involved in the civil trial. I didn't actually fully understand that prior to yesterday. Since the district attorney, if he is going to drop the charges, be a huge disappointment to the Jane Does, it seems like he would at least do them the favor of dropping it with prejudice, so that Danny will have to testify at the civil trial.
Absolutely. And I want to make clear to your viewers, I don't know anything Aaron doesn't know. Okay. I have no reason to believe that the DA will dismiss these charges, but it's something that I came up in the comments. Can he be retried? Can this, can that? This is a video in response to some of the comments that I couldn't just give you 1 or 2 word answers for. It really needed an explanation and a Q&A session. So I have no reason to believe, yes, he's going to be retried, or no, they're going to dismiss it. I have no knowledge either way. We're just speaking hypothetically about what the possible outcomes are.
That's right. And also because some media have reported that this trial is scheduled to be retried, but it's important to understand that is just a formality. It's a placeholder. The district attorney has not actually announced the decision to retry or to dismiss charges, correct?
Correct. The March 26th date or whatever it is, that's simply a placeholder date.
Right.
That's all that is.
You know, while we have everyone's attention, I would like to give some extra information I learned yesterday. I spoke to somebody who was in the courthouse, who was in the court outside in the hallway with the jurors. It was not a juror that I spoke with. And this information sheds light on why we saw, most likely why we saw a 10-2 split on Jane Doe 1's charges. If you will recall, Jane Doe 1's mother was a possible witness in this case. And at the last minute, they chose not to call her as a witness.
Right.
And what I learned that I didn't realize, but I should have known, I almost forgot this. Jane Doe 1's mother is still a Scientologist. And when she showed up to the courthouse that day, the day they were going to call her to testify, she was observed in the hallway being chummy with the defense team.
Okay.
And she was heard in the hallway making a statement, able to be heard by the jury, She made this statement within earshot of the jury that was waiting to go back into the courtroom, contradicting what she was expected to testify to. And the jury heard, so the jury heard Jane Doe 1's own mother cast doubt on Jane Doe 1's testimony. Now, here's why this is so disturbing. It's not Jane Doe 1's mother had personally had in the past completely vouched for Jane Doe 1's testimony and had even written reports on the subject directly to David Miscavige, asking him to do something about Danny. And Scientology, the pressure that Scientology brought to bear was sufficient to get Jane Doe 1's mother to change her testimony at the last minute. And if someone in the hallway had not been able to hear this happening, they would have actually called her to the stand and she would have messed everything up. Now, everything ended up getting messed up anyway. Well,
Right.
not as messed up as it could be, because at least he
Sure.
didn't get acquitted, right?
Sure.
And so I wanted to mention that because the fact that there's a 10-2 split on Jane Doe 1's testimony may have caused some to think that there was something wrong with Jane Doe 1's testimony. And what people don't know is that the jury heard Jane Doe 1's mother contradict the entire premise of Jane Doe 1's testimony on the last day. It was like the last day or two is when Jane Doe 1's mother was supposed to testify. Anyway, that's remarkable. What do you think about all that?
It's interesting, and what I will say is this, because I can't quite read the comments. That's what I was looking for, but I can already hear them in my head screaming, "Oh, I knew Scientology got to them." Scientology didn't get to the jury; they got to the witness. The witness then compromised the jury, and so the jury sounds like they could possibly, and this is pure speculation, may have been a little bit derelict. They're supposed to report those types of contacts and overhearing things, even if they didn't intend to hear it, to the judge. And everybody says, "Oh, well, the jury didn't do that." You know what the judge does if the jury comes to him and said, "We heard this witness talking"? The judge mistries it anyway.
Right.
The outcome is exactly the same. So,
Right.
you know, even if the jury goes to the judge and one of the jurors says, "Judge, I heard something in the hallway. I have a duty to report it to you. I'm following your instructions." The judge would bring the attorneys together. They would probably even ask this juror questions on the stand, and then in all likelihood, the judge would have mistried the case, dismissed the jury, and we'd be right back here, maybe a few weeks earlier than we got here, but we'd be right back here in the exact same position. So the outcome is ultimately the same.
Yeah. Incredible. So let me think. What are some other relevant issues here? Did we already cover everything you wanted to discuss, or there was actually another thing, wasn't there?
Yeah, there was. That's what I'm pulling up right now, and it was. And I saw a lot of chatter in the. Let's get to Vanessa first here. Oh,
I had to put it up. It's a super chat. Thank you, Vanessa.
so the other thing that I had mentioned that I wanted to cover was there was a lot of chatter in the comments over the last several videos about the scale of justice exhibit, and a lot of people saying the judge never should have let it in. It compromised the jury. And I don't think I did and that's on me. I don't think I did a very good job of explaining it when we talked about it before. I just sort of hit it at a glancing blow and moved on. That exhibit is not evidence. Evidence is evidence comes in one of two varieties. It's the testimony of witnesses, and it is certain exhibits that are admitted into evidence, and the jury gets to look at in deliberation. So the classic case is a shooting. Okay, evidence includes the testimony of the police detective and witnesses and the medical examiner, and evidence includes the photographs of the body, photographs of the crime scene, and the gun, and say the ballistics report from the lab or something. That is evidence. If I put together a chronological timeline, or I put together an animated video of what happened, and we actually saw this in the Trayvon Martin case. The defense had an animator build an animation that articulated their version of the facts, and they showed it to the jury in closing. And the judge told the jury ahead of time, the video you're going to see is not evidence. It's what the defense's take on this case is. You don't get to take it back to the jury room and review it in deliberation because it's not evidence. The scale of guilt thing that Cohen built is likewise not evidence. Okay, and the reason it's not evidence is because it's not the law and it's not fact. It is the opinion of the defense on what the reasonable doubt standard is.
Would are there any limitations to what the, well, in this case we'll just say the defense, what the defense can say or do and show in their closing arguments?
There are some limits. So for example, if I'm asking for a sum of money for money damages, let's say the civil case, the sum of money, and I say my client was injured to the tune of $10 million, you need to pay $10 million. Well, the other side can object and say, Judge, there was no evidence that there's $10 million. If I put on evidence that there's $10 million, a witness says it's worth $10 million, an expert says it, or I turn in a receipt for $10 million. Thank you, Marjon Van Leer. If I said that incorrectly, I apologize. I appreciate those words. So generally speaking, in closing argument, it is a very, very broad ability of the lawyers to argue their case. And if somebody's never seen closing argument, it's a little bit tough to explain how it's done. And even when you see it, you generally see the back of the lawyers' heads because they don't put juries on video, on TV or broadcast. It's against the rules to do that, which is why you never see the jury. You just see the attorney talking off screen to somebody. That's somebody's the jury. But so sometimes you see the exhibits or the flip charts or the PowerPoint slides or whatever. One of the classic things we do is we take the jury instructions, especially as a defense attorney. And I'm going to take the jury instructions and I'm going to blow it up and make it real big on the screen and say, this is the definition of reasonable doubt. This is the law you have to apply. And then I'm going to put up my big scale of justice board and say, here's the levels of guilt. That jury instruction goes back. That's evidence because it's the law and the judge has provided it to the jury. That scale of justice board does not go back. So however good they are at taking notes is what they get to remember about the scale of justice board. But those demonstrative displays are not evidence. They are exhibits, but so the jury sees them at the time, but the jury does not get to take that back and apply that because it is not factual evidence of the case.
Some comments that I saw on this subject were like reflecting exactly what you just said, that there's things that are evidence that the jury is allowed to consider. There's things that aren't evidence that they aren't allowed to consider. And that the fact that the jury asked to see an exhibit in closing arguments, not understanding that that wasn't evidence. I saw comments that was like, that's a bad sign because that means the jury doesn't actually understand what they're allowed to consider when coming to a verdict. And the fact that they were back there deliberating with that lack of understanding, I saw some people pointing fingers at Judge Almeida for not having instructed the jury. And I'm sort of wondering what your thoughts are on that, but more so,
Sure.
it seems like to expect a jury to fully and truly understand or to even be able to differentiate between these are the things I'm allowed to consider and these are the things I'm not allowed to consider, like that's not really how the mind works.
Right.
It seems like a real problem that you'd run into with almost any jury.
Yeah. So I will tell you, for those, I mean, I know you've sat on a jury before, but those who've never been to a jury trial, it is the most awkward way to conduct anything. If you've ever been in a commercial shoot, it takes 10 hours to take video of somebody tying a shoelace. It's a really inefficient way to do anything. Jury trials are the same way. It's very awkward the way attorneys talk to the judge, the court, your honor, the court will recall. It's super awkward and formal. So it's sort of odd anyway, but let's take them one at a time. The first question was about the jury instructions. Every state, to my knowledge, don't practice in California, but California in this capacity tends to follow the national trend. Most jurisdictions have what are called uniform jury instructions. And they're approved by the Supreme Court or the Court of Appeals, and every judge and lawyer adopts those. And like in Oklahoma, we call it the Ouija, OUJI, Oklahoma Uniform Jury Instructions. So we shorten to call it the Ouija. And I look them up, and it's civil Ouija, criminal Ouija, whatever. I look it up, and 1.1 defines the role of the jury, and negligence is defined in this specific jury instruction. And so if California has a set of uniform jury instructions, Judge Almeida doesn't get to change them. She just reads them, the ones that are applicable to that case from beginning to end. And so if the jury didn't understand the instructions, that's not really the judge's fault. The judge is bound by what the jury instructions are in a uniform setting. Right. And then your second point was, most of us don't have the ability to partition thou shalt and thou shalt not, which is essentially what, right? You are allowed to consider this, you're not allowed to consider that. And this is exactly why the rules of evidence exist. This is why hearsay testimony, if I put you on the stand, you don't get to tell me what your great Aunt Betty told Uncle Bob 3 Thanksgivings ago. Right? If you've ever played the game of telephone, the message at the end is never the same as the message at the beginning, and most of the time it's not even close. I asked my 3-year-old, what did you say? I asked her again in 20 minutes, a whole different story. Right? And so most of us can't partition. And so it is very difficult to do. And that's why a lot of lawyers, not all of us, but there's a fair group of us in the litigation world who take issue with curative instructions, right? The jury will disregard that witness's statement. Well, you and I both know you can't unhear it. And it's going to be back there somewhere deep in the parts of the brain that we don't talk about at parties, back there rattling around somewhere, and it's going to impact and influence the way that the jury considers the case. But to be honest, I don't know of a way to fix that. If we had to mistry every time a witness slipped up and something came out that shouldn't, the fastest lawyer in the world can't shut that witness up in time. Because you're reacting to what you hear. I can't anticipate it. I'm just reacting to the answer. If it's a fair question and the train comes off the rails and the answer, I can't fix that. The judge will give a curative instruction. And the courts have long said that curative instructions are good enough. A lot of lawyers take issue with that, but that's the law, and that's what we're bound to follow.
Right. And, so essentially, one thing I've heard repeated that Philip Cohen said in his closing statement was something to the effect of, and it was in reference to his scale of guilt or scale of doubt or whatever
Sure.
you actually call that scale. He said, thinking he did it, or he very likely did this, or he most likely is guilty, is not guilty. And that's a mind trip right there.
It is. And if I'm being honest, he's right.
He is right. And
we don't have to like it, but he's right.
That's right. Well, and that's where I was going, is that if it was wrong, then it would have been up to the district attorney to correct that misconception when he had his final say on his closing arguments. Right. And so it's interesting. So people think, oh, that scale of justice, it tipped, it upset the whole thing. It never should have been allowed. Well, the judge isn't free to prevent that from being used. It's not even something unique to this trial. That scale is used in many trials, right?
Yeah, absolutely. And so the different practice groups have different practice areas have industry groups. For example, civil defense attorneys have the Defense Research Institute. Plaintiffs' lawyers, like in the civil case, have the Trial Lawyers of America or the American Association of Justice. Those are industry groups, and they come up with these really good game plans. In the Criminal Defense Attorneys of America, one of those working groups or industry groups, of which I'm sure Cohen is a member, there's listservs. They circulate these ideas amongst one another, and he pops it up and says, here's the rough facts of my case. Here's what I have to overcome. Does anybody have anything to help? And some criminal defense lawyer somewhere says, yeah, I used this and had success with it. Try it out, see if you like it. So lawyers play, what is it? Sam Seaborn in The West Wing once said, good writers borrow from other writers. Great writers plagiarize outright. And lawyers are exactly the same way. A good lawyer will borrow somebody else's concept. A great lawyer is going to steal it outright and do it better.
Okay, good. I'm glad that we went over that on the scale of justice thing. By the way, is scale of justice the wrong thing to call it, or is it the scale of doubt?
So I think according to Tony Ortega's notes, I believe it was the scale of guilt.
Of guilt.
Yeah.
Huh.
So the scales of justice, right? It's the famous Lady Liberty blindfolded holding the scales, and it's got the pans.
Oh, okay.
So that's probably where it comes from, because I made a comment the other day about the scales of justice and how I've used them before. But I think the title of that particular exhibit was the scale of doubt or scale of guilt.
Okay. All right. So we covered that. So back to the testimony in the civil trial. So if he is convicted outright in a retrial, then he cannot plead the fifth in the civil case.
Nope.
If he is acquitted outright in the criminal trial, he cannot plead the fifth in the civil case.
Also true. And we actually saw, well, I was young, but some of your viewers may have saw it. That's exactly what happened in the O.J. Simpson trial. He did not testify in his own defense at the murder trial and was acquitted. Because he was acquitted, he had to give deposition testimony. He told part of the truth and he told part of the lie. But he couldn't assert the Fifth Amendment because even if he says, yeah, I stabbed them both and laughed the whole time, what's the state going to do? Nothing. They can't.
Right. Okay, so it would really be, there's really only one scenario here where Danny would be able to plead the fifth in the civil case, and it seems like that's probably not very likely.
Absolutely. If the DA elects to retry, then March 26th, we're prepared to put a jury in the box. Although I've got to look exactly at my schedule. I'm hoping I'm around when that trial kicks off. I am going out of the country for a week around spring break. So I may be a little bit out of pocket then, but I'm hoping I'm back around a consistent internet connection where we can continue to have these discussions when the trial retries. But yeah, assuming the DA elects to retry, and assuming, which we already have assumed and we're wrong, that there would be a conclusion to the matter after the retrial, then whatever that outcome is, win or lose, conviction or acquittal, Danny Masterson now has to give testimony. If the state elects not to retry and dismisses it, if they dismiss it with prejudice, Masterson's protected. They can't re-prosecute him, similar to immunity for those who. So a few weeks ago we did a video about Lisa Marie Presley's immunity and the different kinds. Go back and watch that if you want more discussion on that. And then if the DA elects to dismiss without prejudice, he can still assert. But I would presume that the DA, common sense, common knowledge, and best practice say that the DA will either retry or dismiss with prejudice so they can move on, because he's got a significant amount of resources in terms of assets, prosecutors, support staff, courtroom staff dedicated to this trial. And at some point, they're going to have to move on and work other files that are on their dockets and their caseloads. So they can't sit here and let this thing just sit in limbo forever. They have other matters they also have to attend to professionally.
Right. Well, for what it's worth, my sources tell me that Deputy DA Reinhold Mueller, which is how I prefer to say his name, even though I don't think he's actually German, that he has every intention of that. You said earlier, it's not up to him to retry. It's actually up to the elected district attorney, right?
Yeah, ultimately. And each DA will handle that differently. Because it's sort of like the Attorney General of the United States. Can the AG, Merrick Garland, try a case in federal court? Absolutely. Will he? Absolutely not. He delegates that to the trial lawyers of his office. And that's exactly what the LA County DA will do. He will meet with the staff. He will take staff recommendations, the prosecutor's recommendations. How likely are we to get a conviction? Can you go through this again? Are the witnesses and the victims going to cooperate with us and continue to go through this again? Those are all things that'll take into consideration. But it sounds like Mueller's on board and he's probably chomping at the bit saying, hey, let's tee this up again. I think I can get him this time. Let's go again.
That's right. My sources say that Reinhold Mueller came out of the meeting with the jury and said, we have to try this again. So hopefully that's what happens. I do see a comment here for you.
So if I can construct 501c3s. Doesn't matter whether it's for veterans or any other qualified nonprofit. However, I am limited to practicing in the states of Oklahoma and Colorado. So if you are interested in that, I am more than happy to have a discussion. You can send me an email, Zac, Z-A-C, at Morgan, MORGANLG.net, if you want to continue those discussions off the air. But it is going to be limited in the areas in which I'm admitted to practice.
Oh, I assumed they were asking you if you run a 501c3 for veterans, but I just realized it doesn't say 501c3. Is a 501c a nonprofit just like a 501c3?
It is. I think they probably just forgot the C, or forgot the 3.
Okay. So just in case that's what they were asking, do you run a nonprofit for veterans?
I do not. I do have several veterans in my family. I have several generations of individuals including my uncle's a career, I have 2 uncles who are career Navy. I got a cousin who was a Marine during Operation Iraqi Freedom and Enduring Freedom. So I do have a long history of military service in my family, but I do not personally run a 501c3 for the benefit of veterans.
Okay. I don't know. Maybe someone was looking you up online and thought they maybe had a different Zac Morgan or something. All right, everyone. Thank you so much for joining us this evening. When we have more to discuss on this, you will you will find us right here doing just that. So subscribe if you're not yet subscribed, hit the notification bell and all that good stuff. And we will talk to you soon. Good night, everyone.